Good afternoon, everyone. I will call this meeting, the Standing Committee on Government Operations, back to order. Today we will be having a public hearing with the Information and Privacy Commissioner to review the 2021-2022 annual report. Before we get into that, I will ask members to introduce themselves, beginning on my left.
Thank you, Mr. Chairman. My name is Richard DeJerk, and I'm the MLA for Tunla-Di-Willity. Let's see. Kevin O'Reilly, Frame Lake. Thank you.
Next to those members online, beginning with MLA Cleveland.
Caitlin Cleveland, MLA Ken Lake.
And MLA Semler. We are joined by MLA Semler, and I will, as soon as her mic is working, we will sort out those technical difficulties. But in the meantime, Mr. Fox, I will pass it over to you for your presentation.
All right. Well, I'll abbreviate and say good afternoon, and thank you for the opportunity to present here this afternoon. I will endeavor to be brief in my opening comments so that there will be time for questions. This is the third time I've been presenting, and Mr. O'Reilly has been there each time, and I will certainly endeavor to be more brief than the first time I tried this. If we could just have a look at slides 2, well, just slide 2 for now, please. And I point this out, these are the two sections from the two different pieces of legislation that I administer, the Access to Information Protection Privacy Act and the Health Information Act. And these two sections stipulate essentially why we're here, which is that annually I have to provide a report to the Speaker about the effectiveness of the legislation. That's on both counts, and to report the activities of the Privacy Commissioner during the year, and to make any recommendations relating to, on the Health Information Act side, relating to that act, and under the ATIP side, to make provide any information about where recommendations that I did make may not have been followed. So I give myself the permission to make some recommendations globally about how the legislation is working, with a view to the idea of what is the effectiveness of the legislation. There are 8 recommendations in my annual report. They appear in summary on page 22. I'm only going to talk about recommendations 2 and 6 today, and tangentially about number 1, which is not to say that the others are not important. There are 4 in here that speak to recommendations for legislative change. There are 4 that are essentially operational in nature. And 2 of them in particular, recommendations 2 and 6, squarely address the need for, in my view, some more resources being put into the system. But I'll sort of get into that a bit more. The report generally, if, maybe we could draw up slide 3, please. Just by way of quick summary, there is some financial reporting in the report. Pleased to say we didn't go over budget. There are some statistics about our office file load. Those statistics are on pages 7 and 8 in the report. And just by very cursory summary, our numbers on both the ATIP side and the Health Information Act side have gone up. We went from, on the ATIP side, we opened 95 files versus 75 from the year previous, which was a bit of an uptick from the year before that. So there's a general increasing trend. That doesn't seem to be going on on a continuous upward slope, so that's of some comfort. I suspect that COVID had something to do with that. On the health information side, we saw a massive uptick in number of cases. We went to 206 files, up from 87 the year before that, which was a significant increase from the year before that. I was rather concerned about that, certainly when I was writing this report a year ago. With another year going by, I can say that's clearly a spike on the graph. I think it's fair to say that was certainly directly reflecting activities of the COVID Secretariat, which had some privacy breach issues, and also within the other health information custodians. There was a significant uptick, but that has died down quite a bit this year. We're still on a bit of an upward trend, but not like that. So that's, comforting. But nevertheless, the number of files has been significant. It certainly outstripped our capacity to close them off in any sort of timely basis. We don't lose jurisdiction because time passes, but it continues to be a challenge. Operationally, we have struggled to keep it full complement. We had our assistant commissioner retire this year, and I think we're just about ready to hire a replacement. So hopefully within the next year, things will really get in tune. Now, the influx files was a bit of a challenge for us, and as I say, a number of the files came from the COVID Secretariat. Approximately a quarter of them came from there. And some of those that were reported to us came in 6 months, even a year after that custodian knew that the breach had happened. Now, the standard in the Act for notification is as soon as reasonably possible, and that's reflected in the Department of Health's privacy breach policy, which makes sense, and why the delay seems to be attributable to, well, at first instance, attributable to lack of staff and perhaps lack of training and lack of policies. The lack of policies was specifically cited to us as a reason for this, which I was somewhat uncertain about, given that the Secretariat was housed within the Department of Health, which has a fairly full complement of policies that were directly applicable, and there's no reason to have expected that the unit operating within the department wouldn't simply adopt and use those policies. But that's not the way it worked. That's problematic. And I wanted to bring this up mostly to make a side note about something that was published by the government not that long ago, which was the lessons learned document regarding COVID Secretariat. And, that was a fairly broad-ranging report that was done. I was somewhat disappointed to see that ATIP and HIA barely gained a mention. The only mention I saw in there was a recommendation or an observation that it was difficult to meet the timelines, and a recommendation that, quote, legislative processes and timelines within the Access to Information Act, and 3 others, should be re-examined to determine whether they are effective and achievable in an emergency response situation. Recognizing I'm kind of diverging from the report here, but I think this is worth taking a look at because it's contemporaneous. That recommendation and the observation that was difficult to meet the timelines is, I suppose, a fair observation because the timelines were not being met constantly. Now, this legislative assembly addressed the timelines specifically, the timelines in the ATIP Act, in the COVID-19 Pandemic Measures Act, and specifically said those timelines are to be maintained. So it landed a bit hollow when we would get explanations for delay saying COVID has impaired the ability to respond in time. I'm talking here about not just delays in privacy breach reporting, but also in terms of various public bodies' ability to respond to access to information requests. And the recommendation about examining to determine whether the timelines are effective and achievable strikes me as maybe not reflecting the same value for ATIP, for access to information, as the Legislative Assembly seems to have, because arguably during a crisis where government is intervening in people's private lives and so forth, is a point in time where access to government information is perhaps even more important. And it'd be my submission to this committee, insofar as it's capable of influencing this, that planning, future planning for the next crisis, not really sure which one it'll be or what it'll look like, but we can be damn sure there's going to be one, more than one, that the planning should be oriented towards planning how to deliver on the timelines, not wondering if we should discard them or carve away at them. And it's fair enough to say that the real challenge in responding in time is resources. And that's something that government will need to struggle with. But in my submission, it would be not the time when you're looking at how we're going to plan for the future and for future crises, that's not a time to place government under less scrutiny. It's really something that the Assembly should be focused, and the government should be focused on planning on how to keep the public informed. So, the issue of resources, I said, was going to figure prominently, and if we can go to slide 6, it's the summary of the recommendations, and recommendations 2 and 6 are highlighted there, or will be. Slide 6. One slide more, I think. There we go. So this recommendation is geared towards the Access Privacy Office. The recommendation, the public bodies that rely on the Access Privacy Office to discharge their ATIPA obligations should ensure on an ongoing basis that the Access Privacy Office is staffed and resources to a level reasonably adequate to the task. Now, I'd like to do a little bit of a history of that office to sort of explain, I think, where we're at. By way of summary, where we're at is, July last year, I attended a deputy minister's meeting with the Access Privacy Officer, and she advised that room that the APO office was late in responding to access requests a little over 50% of the time. I'm advised about a month ago that hasn't changed. In my view, that's not an acceptable service standard. I can't help note that the changes to the Act that came into force in July of 2021 did shorten some timeframes. But it doesn't appear that thus far the APO office has been able to meet that challenge. And I guess my first point is that I think the Access Privacy Office is an excellent approach for the government to take. It really can work. It offers us some real advantages because it allows a cohort, albeit perhaps a bit too small a cohort right now, of professionals to do the work, which is not easy. It's not simple. Certainly, interpreting and applying the exemptions disclosure in the Act is at times difficult. And certainly I've had a number of discussions and debates about the appropriate interpretation of some of those sections. So professionalizing that, great idea. Now, that Access Privacy Office has only been around for a couple of years. So we're really still in the, not training wheel stage, but really testing it out, seeing how it works and how it might improve. I'm quite impressed with the dedication of the people that work there, but it's at some point it's a sheer numbers game, and they have been pressed to keep all of their positions staffed, and that's certainly not something that's idiosyncratic to the Access Privacy Office, but it's a problem, and I think there may even be a sort of historical problem there, because when the Access Privacy Office was first created back in, I think, 2020, it became it became an office in 2020. In October of 2020, the Section 68.1, which allows public bodies to assign as their coordinator, more than one public body can assign the same coordinator. So that's when the APO office became possible. And they went live, which is to say they started taking on responsibilities for public bodies that they serve in March of 2021. So they really haven't been at it that long. Now, before they took over doing the responses for all 9 departments, they act for all the departments except health, plus housing, they were acting as the coordinator for the Department of Justice. Well, they had 4 people there then. And then when they took on all the other departments and housing, they became 5. And I think that's the problem. And I know that there is a request for the approval of more staff. I wrote a letter in support of that earlier this year. And as far as I understand, that somehow didn't get dealt with at the regular budget process and is being reviewed or considered further. So in as much as this committee can maybe influence that, it seems to me that that group needs a lot more support. It's a great idea, and I think if you build on it a bit more, it can really perform well. And ultimately, the Legislative Assembly decided to create some new timelines, faster timelines, raising the expectations of the public. And government needs to respond to that, it seems to me. Now, when I came into this job, one of the first things I learned was that the access privacy coordinators in a number of the departments were not actually sort of experts or well-trained professionals in this. It was, these were people who were occupying a position, but it was an unfunded position. They already had a full-time job, and this was, more or less of a corner of the desk sort of activity. And, a lot of the public bodies, I presume, didn't have enough regular access information work to keep someone busy full-time. And they didn't have them on their organization charts with a funded position. So when the APO came along, able to then absorb the large chunk of the work in processing access requests, well, there's presumably some relief there for the public bodies because now they don't have to do that work. But they're still the ones responsible for processing those access requests along the timelines that the Act states. It doesn't lie for the public bodies to say, well, we did our bit. It's the Access Privacy Office's fault because they're backed up or they're not doing it fast enough. There are only 4 reasons to get an extension of time under the Act. And work backlog really isn't one of them. The one threshold that deals with the amount of records, if there's too large an amount of records to process within time, the threshold has to meet unreasonable interference with the operations of the public body. And that's a relatively high threshold. You really got to demonstrate that, you know, we've done all we can, it's just going to take longer. But generally speaking, I don't see that kind of information. When I dealt with a request at one point for, I think it was 100 business days extension, and my request for information about what was the public body doing, the answer was nothing. Not surprisingly, the answer was no. Which is not to say that I had a reasonable expectation that the Access Privacy Office was going to be able to, you know, pump it out the next day, but there has to be actual facts that fit the legislation. And I sort of, not dancing around the point, it's the public body's responsibility, and it seems to me that the reliance on the APO is a really good idea, but only if the public bodies have actually had a thought about it and decided reasonably that they can rely on that body. And I fear that what might be going on is that the public bodies are sort of, well, shrugging off, say, well, now we've, you know, that's who's doing it. We don't have to much. And the Department of Justice will fund it because that's where the Access Privacy Office is located. And I mean, who's paying for it is just an accounting question, I suppose. But fundamentally, all of those public bodies have a real statutory obligation, and it would be a mistake to think that you can really accomplish these sorts of pieces of work for free. It's not real. So, you know, either collectively or individually, it seems to me that the public bodies have to consider the issue, is the APO sufficiently resourced that it can do our work for us? And that's what that recommendation is trying to get at. And so, you know, again, in as much as this committee can pose that question to the ministers, who are the heads of the public bodies, who ultimately are the ones with these obligations, I would urge you to do that. Now, I'm going to turn a bit to recommendation 6, which deals with the training issue. And this isn't the first time I've made this recommendation that health information custodians need to prioritize training, notably, you know, privacy training for their employees. But it bears repeating, and we saw some real problems within the COVID Secretariat of compliance with, you know, the applicable mandatory training policy within the Department of Health, which requires not only training during onboarding prior to taking on responsibilities, but logging of that training, regular refreshing of that training, and in a dismaying number of investigations and reviews of these things, the training comes up either an empty set or an unknown set. And that's a problem, because there may not be immediate financial implications for a public body if there's a breach of privacy, but there can be a carving away at the sort of confidence of the public in that system to keep their information private, and that is an important value. But by way of example, you know, everyone knows the, you know, an ounce of prevention's worth a pound of cure kind of a adage. And on the ATIP side, we had a review last year that really underscores that. The Department of Infrastructure had been using the DIM system, Integrated Information Management System, and had set up a number of files. It was I think it was a director level person set up a whole bunch of files with a bunch of human resources information in it, lots of personal information. These had been set up for a couple of years, and there were absolutely no controls on the access to those files. And someone figured this out and was, I don't know, innocently or otherwise, snooping around and looking at people's stuff, and then told one of their coworkers, hey, you can go and look at your stuff, and it's right there. And so it eventually came to our attention. And, I mean, the legislation is very clear that public bodies have to provide reasonable security measures to protect personal information. And public bodies, which includes all of their employees, are not to access information unless there's a lawful reason to do so. And snooping isn't one of them. But what happened was really instructive, because it had been open for so long and there had been quite a lot of activity, and there were at least hundreds, I want to say thousands of files that were involved. It took that department to appoint 5 people full-time for 6 months to sort out, to go through all the audits, to review all the access points, to provide all the notifications to all the people, etc. It was a major task, really expensive. So, you know, in comparison, a little bit of onboarding training for the director when set loose on DIMS, self-evidently something that needs to happen. The problem is that there's that, well, we could do it next week and it'd still be okay, because probably nothing will happen. Risk is hard to evaluate sometimes, and that's why we put the rules in place to try and ameliorate the risk and help managers and others ameliorate that risk without having to do their own calculations about risk and what's a reasonable response. Training is a pretty reasonable response. If employees don't get it, they won't know what to do, and they're probably ill-equipped to figure it all out on their own. They might not know what to do in terms of avoiding a privacy breach. They might not know what to do in terms of an appropriate response to a privacy breach. I don't know that I need to belabor that point with this group, but it seems that training is expensive, and because of the seemingly constant churn of employees in positions in various departments, it is a constant challenge. But it just cannot be something that's left for next week or next month. So, the recommendation. I have one more comment I'd like to make, and maybe it's a little more upbeat. And this goes back to the issue about costs and ATIP. As some of you probably have been reading the Globe and Mail. There's quite a spate of articles going on over the last couple of weeks about freedom of information. And one of them that really caught my eye was citing a Federal Treasury Board study about the costs of freedom of information, and the per-page cost for delivering access to information was something astounding, like $11 a page or something. And this is rightly identified as really a lot of money. Now, especially in an age where our creation of data is really outstripping our ability to manage it properly, and certainly to produce it. And the article pointed out that, well, one of the ways to potentially approach this, and this is the Treasury Board idea, is that if public bodies put the information in a publicly accessible place on the web where people can look at it, that costs pennies. And I mention that not because it's a good idea, and it is, but it seems to me that one of the amendments to the Act that the Legislative Assembly put in place likely was geared towards that kind of idea. Section 72, now, previously Section 72 permitted public bodies to create categories of information, not personal information, that could be available to the public. It was changed, and now it requires, it's a mandatory clause, requiring public bodies to create categories of records that can be available to the public, and to publish those categories. And then the public can essentially, request copies of whatever records they might want. And if for a fee, presumably, if that's necessary. But the beauty of that is that it could go on, expressly contemplated to go on outside the formal access to information process, which is an expensive process. So this recommendation isn't here because, frankly, I wasn't thinking about it a year ago when I put this together, but that section is part of the amendments. I don't know. I've just recently put an ask out to the APO office to see if they're even tracking that. Wouldn't surprise me if they weren't, because it's contemplated to be something that's going on outside their ambit anyway. But that could be a really useful way to get information out to the public, make it cheaper, make it more accessible. It's hard to see the downside. And the only obstacle I could really see to it, other than being, well, it would take some work to actually create those categories and do the work to publish it, and that won't go for free, although it will go a lot cheaper. But again, if you're a public body and you're getting the APO's services for free, then the beauty of a less expensive option still looks like an additional expense. But there's also a culture change that maybe needs to occur too, because I've certainly observed in access to information reviews that there is a dismaying tendency for heads of public bodies, even over, I suspect, the advice of the Access Privacy Office, to redact wherever possible, rather than redacting only where, where there's discretion, and where it makes sense, where there's actually some advice that's important to hold back, as opposed to see Member O'Reilly chuckling a bit, but I think he's aware of a decision that came out with a couple of months ago, which basically refuted most of the redactions that had been made by a department, and it was basically on the basis that the exercise of discretion was hard to understand, even where it existed. Because why would you hide a good news story? Why would you hide facts that are anodyne and non-controversial? And I think that's a culture issue. That's a culture of, well, it's the government's information, so unless we have to give it up, we're not going to. But the culture, in my opinion, should be moving more towards, this is the public's information that the government holds for its benefit. There are, in the Act, a number of reasons why the government might choose to hold back information or be required to hold back information. But those calculations are done within the legislation, and they are for the purpose of protecting the overall public interest. It's not there to protect the government's interest. At times, maybe a subtle distinction, but I think there's a fundamental culture value there that hopefully we will continue to see changes on. I like to say that my office is engaged in a process of constant refinement, and I think that's true. And I think that some of the changes made, particularly the Access Privacy Office, is a big step in terms of improvement and refinement. And again, just in closing, I'll just urge that office should really attract all the support that this government can give it. So happy to take any questions, but those were the comments I wanted to make.
Thank you, Mr. Fox. Are there any questions, comments from committee? Rylund.
Thank you very much, Mr. Chair, and thank you very much to Mr. Fox for the presentation today. I wanted to start with a couple of questions and thank Mr. Fox for reference to proactive disclosure. And that's something that even on this side of the House as regular MLAs that we frequently go back on is when we receive letters from the government, quite often they're marked confidential. And once we go through the letter, we realize, well, this is all, in fact, actually already public information. So there's kind of this built-in, like you say, corporate culture of marking everything confidential without asking why. And so I'm wondering if Mr. Fox could potentially speak to the different requests for ATIP or access to information that come across his office, and whether or not he can speak a little bit more in detail to the specific themes around what information people are generally after, that they are kind of meeting up roadblocks as to accessing that from the government. Thank you.
Thank you, MLA Cleveland. Mr. Fox?
Thank you for that question. I'll say right away that kind of invites me to speculate, which I hesitate to do. The reason I say speculate, because my office sees a subset of the access to information requests that go to the Access Privacy Office, which is the window for access requests. So I see the request for review from unsatisfied customers, put it that way. And of those, I would say that one group of those would be people with human resources issues that are pending either in some sort of union grievance process or some other kind of HR uncertainty, and they are frustrated in their ability to get hold of documents through those processes, and so they try to get them through access to information. And then one of the problems with that is that the Access to Information Act has rules about protecting personal information, notably the personal information of third parties. Redaction starts creeping into these documents, and that tends to lead to dissatisfaction with the product that comes out of the access to information process. And the reason for that is entirely reasonable, is because once information is made public to or in an access to information request, it's public. So there aren't any restrictions that you can place on the use of that information on the applicant. Whereas in any kind of HR process, generally speaking, conditions can be placed on it. So you could give an unredacted document to someone who's a complainant or litigant or a griever in a process, and say, okay, here's the document, unredacted, but you can't talk about it or use it somewhere else. So those are different, meaningfully different sometimes. And we see people, there's a significant number of people who are stuck in that situation. Now, we have very few people that come forward saying, well, I have personal information that is incorrect in someone's registry. I've had one of those, I think, since I've been here. We have had a number of cases dealing with certain departments, finance, infrastructure, industry, tourism, investment. These seem to be places where there is a fair bit of economic activity and personal interest in that economic activity. And so when the predominant complaint is when you get the response from the public body, it's got redactions on it that someone doesn't think that are reasonable. And it's often difficult to know if they're reasonable because they're redacted. You don't know what it is being hidden. And there's a very natural inclination to think, oh, well, that must be the important stuff. Often that's a mistake, but you can't know because you don't see it. So that's the function that my office brings, because we do get to see it and we can weigh in the balance whether we think the exemption that's claimed is valid or not. I think that the public bodies have been content to take the decisions in stride. I have not seen any of them be appealed, because now that they are orders, the only way to not be bound by it would be to take it to court. I think last year Member O'Reilly was asking about enforcement of these orders, and my office does not proceed to try and register orders with the court, even though the Act says that they are registrable as orders of the Superior Court. And for the one reason that there is a separate section that says expressly that the government is bound to follow the orders that are made. So we expect the government to follow the law. And I don't think there's any reason to spend the effort to go to court to register an order just in the hopes that that would bind a government. So I think when the decisions come out, they are followed. I think I maybe went a little bit further than your question asked, but I hope that answers your question.
Any follow-up, Emily Cleveland?
Yeah, thank you for that, Mr. Chair. The other question I wanted to ask was in regards to the time required to complete privacy impact assessment. And within the recommendation, it identified needing more meaningful time to do that. And I'm wondering if the Information Privacy Commissioner can speak to what would be a reasonable amount of time for that work to be done. I know that even us over in committee are asking for departments to do some of this work as well. And so I think understanding kind of what time frame is reasonable would be helpful on both sides. Thank you.
Mr. Hawk?
Well, that's tricky. We've got privacy impact assessments under the Health Information Act. I think we've made comments over the years about problems with that, problems of the kind of, getting a privacy impact assessment delivered on a Friday for a program about to go live on Monday. And I don't jest. I certainly got within the last year at least one or two for programs. These would be PIAs coming from the Secretariat for programs that had been in place for 6 months and were due to be actually terminated. I'll deal with that from right now. The problem being is, I think with the HIA is that there's very, very little in the Act to help in terms of directing health information custodians on timing or what they're supposed to do with any comments or what they're even supposed to do in terms of timing. It's a very cursory treatment of PIAs. Now, in the ATIP amendments, there are new sections. There weren't any PIAs required under ATIP before, but now there are. And it's good to see that there is a direction there in the Act, which reflects, I think, probably the policy development that was going on at the same time. The privacy impact assessment policy that GNWT put out in 2019, and it says to prepare these things sufficiently ahead of time that they can be reviewed and commented and have those taken into account during the planning phase. Now, we only see some of the PIAs that would be done by public bodies because it's only projects or programs that are common or integrated, which is to say things that involve more than one department. Those would be the PIAs that we would see. But for any project dealing with an information system or personal information that a public body is using, well, the head is supposed to get every PIA for those. So as a process, as a planning tool, it's written right in there. And in the ATIP, it says, in a reasonable time, sufficiently early on in the planning phase that the comments can be taken into account. So, I mean, if your question was, should it be 3 weeks or 2 months, I don't know that I can really answer that because some PIAs are fairly straightforward and they might be 15 pages long and quite a straightforward project. Some are 40 pages long. Some of them might have taken, a few weeks to produce. Some might have been worked on for a year. So those are distinguishable cases for us. Typically, I retain a consultant to help do that work, and it's an iterative process as well, because we just got through dealing with one PIA, which was for an integrated program involving, it was finance and lands and infrastructure, and it was a very early one. And there were questions left that were clearly not answered, but it was really encouraging to see that, because it was clearly contemplated that it'd be coming back to us with more information. So it's, in an ideal form, it's not a one-stop, tick box, okay, we did our PIA kind of a process. It's supposed to be an iterative process, which means more time. And if you're going to involve the pesky old information commissioner, then it's going to require even more time. We try to get it out the doors as soon as we can, but realistically, it would take at least a month or two to be able to turn something around, and that would be quick.
Thank you, Mr. Fox. Next on the list, I have Emily O'Reilly.
Yeah, thanks, Mr. Chair, and I'm glad that the Commissioner mentioned this notion of mandatory disclosure provision in the new legislation, and proactive disclosure, and I'm glad that my colleague from Cam Lake mentioned that as well. So I'm constantly fighting this battle, this government, to build in public disclosure requirements, public participation requirements in legislation. It's almost every single bill that comes forward, whether it's the Forest Act, UNDRIP implementation, even carbon tax. And some of the tools that I am constantly trying to get them to think about and incorporate are, requirements to make documents public, or public registries, or annual reporting. Those are kind of the common tools that I kind of think of, but I just get a sense that this government is actually getting worse at doing these things in my 7 years of being here, which is not a great start or whatever. And it seems to be a lot of new things that come along with devolution or evolving public policy. Even though we have an open government policy the cabinet has signed on to, they just don't implement it. So I'm just wondering if you have thought about any of this stuff, and maybe when you get your response from the APO about how they are implementing mandatory disclosure, I would just hope that you can kind of think about some of the stuff that I said here about what kind of tools and guidance they should have in place for, how do we change that culture, that way of thinking that everything needs to be secret, or that, to turn it on its head, to say there has to be some good reason why something is not public, to shift the onus. So anyways, all of that to say that when you get information back about mandatory disclosure, I hope you can kind of think about these things and maybe even make some suggestions or provide some guidance or ideas about how we can change that culture and make a shift to, making a common practice that these things become part of legislation, policy, and the way that public servants and that the public service actually acts right from day one. Thanks, Mr. Chair.
Thank you, Emily O'Reilly. Mr. Fox.
Well, first, just let me clarify a thing. I did ask the question of the APO about what do they know about what Section 72 is, how that's being implemented. But I think I said, but I'll clarify. I don't think they would be where that activity would be going on anyway, because that's contemplated to be outside the access to information process. And they, as you might have gleaned from my comments, they have their hands full already with the formal process. Culture change, yeah, I think maybe they're There needs to be, but I would also hesitate to be perhaps as glum as you expressed. Maybe I just haven't been with the government long enough, or sitting close to it. I'm not really part of the government. But I would say that there's probably room for hope as well, because in some initiatives you do see information coming out, and maybe as difficult as it was to adhere strictly to the Health Information Act, COVID Secretariat was a shining example, I think, about how the government was able to get out in front of information that the public needed. There was a lot of it. You know, going to the web is where most people will go for information, and you could find much of what you needed. Now, I, like anybody else, can find fault with the interface sometimes, and whether information is arranged, organized the way I think it should be. But there is always room for improvement. Doesn't matter what you're doing. But where that understanding is alive, that the public needs to know this, I think the government can get behind it. I think the culture change needs to happen in terms of viewing more of what the government is doing as fitting into that column of, you know, does the public need to know when the government has a contract to rent space in an office building? Well, I suppose you could ask the question, well, why should anyone know that? I say, well, it's government financial activity. Why wouldn't you have that on a list somewhere? It eventually does get published somewhere. Why wouldn't it be? Why wouldn't that sort of activity, among all kinds of other government activities, simply be put out there? If it doesn't contain personal information and it doesn't require redaction or so forth under the exemptions in Division B of Part 1, then presumptively one would think it should be in the public realm, because ultimately it's the public's information. That's whose interest is being held in. And, you know, I think there is for people in government, I think there is a natural inclination to be somewhat hesitant. You know, the phrase in my profession that law, like sausage, should not be seen to be made. And there's something to that. There's, you know, sometimes the discussions and the things that government gets involved with can be, in retrospect, embarrassing, can be taken out of context, very embarrassing, and there is a natural inclination to avoid that embarrassment. And I think it would constrain government too much if absolutely everything had to be public. There has to be some, you know, safe space to have full and frank discussions. My personal thought about that is that sometimes that's interpreted a bit large, and I'm always sort of careful to wonder to look at exemptions claimed on that basis, see whether they really fit. So I think there is good reason to think that the government is capable of doing it and of doing more in the way of disclosure, but it comes, as I say, there's a culture shift that is probably going to be needed, but there's also going to be some work involved, and that's problematic. I mean, I think if you can sell proactive disclosure of government information as a really good deal economically, that's a very easy sell. But if no one is actually committing budget resources to ATIP as it is, then what you're really selling is an increase and another budget commitment, and that's not such an easy sell. I'm not quite sure how to fix that, but it strikes me that on a global level, you know, on a whole of government level, the argument's fairly easy to make, the economic argument. And in the operations of the Access Privacy Office, that is a service that is provided to the whole of government. Now, I mean, government departments are, and the Housing Corp represent a third of the Crown corporations and agencies that the APO, that are subject to the Act. So the APO is only helping those folks. The other folks are still out there on their own trying to do as best they can. But APO is there to serve the government, and it's doing so across the board. So in one shape or form, it seems to me the sort of economic argument should be easy to make to somebody, whoever's paying for it, which would be Department of Justice, I think.
Thank you, Mr. Fox. Are there any further questions, comments from the committee? Lawyer Riley, last question.
Yeah, about three things I could try to wrap up here. No, thank you for the response. I guess maybe one quick observation. I think you're starting to report some more statistics in your report, but it would be really interesting to see a breakdown by departments to see if there's any kind of frequent flyers when it comes to inability to meet deadlines and that kind of thing, some systemic issues or problems. And I would maybe urge you to look at the Ombud's report to get an idea of how you might structure some of the stats and report on that a little bit better. But I want to ask about, I did raise the issue of, the orders that you issue now, and thanks to the last assembly or in this assembly, wherever, for getting that new jurisdiction for you. I think departments are probably following those orders, but what I want to know is, have any departments ever gone to court to dispute your order? If so, be good to get that kind of level of detail. I'm sure you reported in your annual report, and I know that it's new authority and it probably hasn't happened yet, but sooner or later, some department's going to dispute your order and going to take it to court, because I think it's even happened with some of the other commissioners across the country, but I assume it hasn't happened yet, but just want to confirm that. Thank you.
Thank you. Mr. Fox?
Short answer, no. No, it hasn't happened yet. I suppose when it does, it'll be big news. Because frankly, that would be an expensive proposition for the government to take on, and it would have to be something, I would think, of real significance. So I guess we will wait and see. But I do note that when, the way the Act works, if a public body doesn't like my review decision and order, and then they go to the Superior Court, the Superior Court doesn't ask itself the question, did I get it right? The Superior Court just deals with it as if it's a new review request. So, formally speaking, I wouldn't have any standing in that hearing, and I might hear about it because it's a small town, but I don't know that the Act doesn't say anything about giving notice to my office or having any reason to give submissions or anything like that. So I'm curious to see how that rolls out, and I tend to agree at some point it probably will happen. Hopefully not on my watch.
And with that, thank you very much, Mr. Fox, for your presentation today and your 2020-2021 annual report. And as there's an election coming up, this will be your last time before this standing committee, so thank you for all your work over the years. And the next standing committee will book a meeting on your next annual report.
Thank you very much for your time and attention, and best of luck with the rest of the afternoon. I gather you've got somebody else coming.
Yeah, and with that committee, we'll take a 5-minute break and resume with the Ombud. Good afternoon, everyone. I will resume this meeting of the Standing Committee on Government Operations. We will be having a public briefing today on the Ombud's Annual Report 2020-2021. We are joined online by Lisa Semler, MLA in Newbergton Lakes, and in the room we have MLA Richard Jericon and MLA Kevin O'Reilly. I am MLA Rylund Johnson, as well as staff, Cynthia James and Nigel Woodrich. And with that, Ms. Langlois, I will pass it over to you for your presentation.
Okay, well, thank you very much, Mr. Chair, and thank you to the committee for your time. I know you're at the end of a couple of really long days of meetings, so I'll try not to go on for too long. So I'm presenting to you on the 2021-22 annual report, and that was our second full year of operations for the office. You know, it's often said that ombuds have two sides to their mandate. One is firefighting, so that's the handling complaints, and the other is fire prevention. So that's stopping the complaints from happening in the first place. And it was really interesting going back to this report. I mean, because I haven't looked at it in a while, but what really struck me was how much we accomplished on the firefighting side, on handling individual complaints. So we opened 182 files and we closed 203, and the reason for the difference is that we had quite a backlog from 2021. We had just trouble keeping up with complaints in our first year, and we were able to clear that. We filed our first 3 special reports on investigations, including 25 recommendations to authorities. So one was on the homeowner assistance program, one was on property assessment and taxation, and the other one was on business assistance programs. So in terms of the cycle, those reports came out a couple of years ago, and there is follow-up to that. That's maybe what you could call a fire watching role of the Ombud. So we are working on an update to what happened to those recommendations that hopefully will be ready for August. So that is part of our cycle as well. That's coming. Last year there was a concern raised about how long our investigations were taking, and we did get some really complex complaints shortly after we opened, and there were a few of them that all required investigations. We had one that took close to 2 years, and as we outline in the report here, we don't think that's acceptable. Like 12 months really should be the standard, and we've been able to keep to that since then, so that's what we're working towards now. So the credit for getting all that work done, the 182 new files and the 203 closed, I'm the person who shows up to these meetings, but of course there's a team at the office that works on these things, and they work full out for that entire year. You know, with experience comes efficiency gains as well, so you know we are more efficient at resolving complaints, but we had 2 staff there that were working really full out and really dedicated to get through those files. This year was also during, of course, still the COVID public health restrictions. So we were doing very little outreach work, particularly in-person outreach work. The publication of the special reports really helped because we got some media coverage with that, and quite a few people when they called did tell us that they heard about us because of coverage on the special reports or they'd read the special report. And one of the reasons why I did so much publishing is because this is a new office and people are still, you know, trying to understand how it works. And I think it's really helpful to map, you know, these really abstract principles of administrative fairness to people's actual stories and what can be done about them. The other thing, I've heard this, I don't know it's true, but, you know, I'm encouraged to hear it might be happening, is I think these reports get shared possibly at the deputy minister's table and maybe among departments as well. And I think that if that's happening, I think that's really beneficial because a recommendation I might make to one department might actually apply to a program in a different department. People might see some connections there. So for example, if I'm talking about plain language, if I'm talking about, you know, upfront communication with people, that could apply across the board. So if people are taking lessons from these reports, even if it doesn't apply specifically to them, I think that's really fantastic. So the one bit of outreach work that we did that was really exciting was we got to go up to the Great Northern Arts Festival. There was a little window in there between the Alpha variant and the Delta variant where there were some summer activities like that were able to take place. that was really worthwhile. We saw our complaints from Beaufort Delta region go up. In the past year, they were really skewed toward South Slave because our office is in Hay River. And also, we get people coming from Fort Resolution and Fort Smith and Kakisa, and KFN, of course. So we do get other people come in. So it was really nice to see more interest and more activity from Beaufort Delta. Just a great opportunity to connect with a lot of people, including people that might pass on information about the Ombud office to friends and family who might need our services. So that was a real success. I was glad we were able to do that. So this firefighting part of the mandate, the handling individual complaints, it is really important work. I don't want to minimize that. The reason we have ombuds is we have a crisis of access to justice in our country, and having a service that is free, where people can bring up their concerns confidentially before they even commit to making a complaint or taking it further, that can address things that can't be dealt with legally, that can't be dealt with before the courts. So, for example, we deal with a lot of matters that somebody theoretically could take to court. This appeal process was unfair, or, this decision was unreasonable. We also deal with a lot of things that could never go before a court. I didn't feel comfortable going into that office. I thought people were really unfriendly. I wish somebody had taken more time to explain what this meant to my dad, because he needed some extra time. So we deal with those matters, which there really is no other recourse for them. I will also say, even if somebody has the resources to hire legal counsel and has the time to wait for a decision, they're not about to be evicted or about to lose their business, and they have time to go through a process like that. There's a real heavy, I think, psychological weight for some people to getting into an adversarial process. So going to court, going to a tribunal that I think our process helps avoid, because we're very different from an adversarial process where each side has to present their case and then there's a decision maker that decides. We're what's called an inquisitorial process, which means the person brings their concern to us and then we'll go and ask the questions, we'll do the investigation. There isn't the onus on them to show up with a really well-prepared case. Of course, we want them to give us documents and any information they have that can help us out. We may need to go back to them for clarification, but they're never put on the spot of having that one opportunity to make their case and try and look out for their interests. So it does take some of that weight off of people. I think that adversarial processes can be really stressful, and when there is some, well, maybe I'll leave that. The other aspect that's really important to our process is the impartiality. So we don't take sides between government and complainants. We're on the side of fairness, is what I say. And also the independence is really important. That's why people trust us. It often happens, not all the time, but it often happens that we end up telling the complainant the same thing that the public service worker would have told them, or a different statutory officer would have told them, or some other person might have told them, but they just feel comfortable that when they hear it from us, it comes across as more trustworthy, because they know that we're impartial and they know we're independent from government. It's not a minister that's telling us what to say. It's not a senior manager that's getting involved. So I do advocate for that independence quite a bit. I have been working with the clerk on some possibilities to just enhance that and make sure that's protected. It's something that's very important, and it's really the goal there is to make sure that we preserve that trust that we need to earn from citizens, because it's as much perceived independence as actual independence. So with these complaints, we are getting procedures fixed. We are resolving things for individuals. One of the important things we do is help restore relationships, because you can imagine if that relationship of trust has broken down, there's a lot of people that really depend on government services, and if they don't trust the worker that's steering them through that process anymore, that can put them in a really, really bad position. Some people won't go use the service anymore, or they'll use it, but they don't believe anything the person is saying, and every time they see them, there's a confrontation. So we've been able to help some of those relationships improve. One of the things I hear, and my staff hear a lot, is you guys answer your phones. That's really, really important to people. You guys actually answer your phones. And we do, right? And, you know, it's part of the characteristic of the process. We'll just hear people out. And people don't, you know, when they're going through a difficult time, it doesn't necessarily fit into a particular category or a particular provision of an act. Like, for them, it's just all happening at once. So if they need to go on a tangent for, you know, a few minutes about something their ex did, which obviously has nothing to do with us, and then something that happened with the police 20 years ago, and something that's happening now. And, you know, we'll just listen to it all, and you know, it's for us to kind of be listening and tracking that, and being empathic, of course, but also kind of figuring out, okay, what are some things that are actually things that we could look at, and what are some referrals we need to make? You know, do we need to be suggesting that person go talk to human rights? Is there a privacy issue there? Is there a process at the department they should be going back to? You know, and is there something that we need to look into more? So we do provide that service, and that's really important, because what I hear, I don't know that there's anywhere else people can go to get that. It's part of being a general jurisdiction ombud that makes that possible. Sometimes individual complaints do lead to systemic changes. You know, I always try to look, particularly when we do a full investigation and make a report, if I'm going to make recommendations, that they're going to prevent this thing from happening again, not just solve the issue for the person. So we might say that person should get an apology, but then we're also going to make some recommendations so other people won't be in that same situation. So yeah, that firefighting role, those individual complaints are a really important function. Ultimately, though, what we really want to do is preventing complaints. When I interviewed for this position with the board, this would have been in the last assembly, I told them that my vision for this office was that it would be like, I don't know if you remember those commercials about the Maytag repairman, who was so lonely because Maytags were so awesome and he never got any calls. So that would be my vision for this office. One day we don't need an ombud at all, because people feel so empowered to speak up for themselves, and they understand their rights, and everything is fair, and we don't need this service anymore. So I think most ombuds probably would have some version of that where, you know, we would all love to see ourselves work ourselves out of our role. Now, that's not going to happen in the few months that I have left in my mandate. But it's you know, when I'm looking decades down the road, this is where I hope we get to. So what gets us there is that fire prevention work, and what I mean by that is the other side of our mandate, which is the own motion investigations and the public education and outreach work. So I you know, this is getting into work that happened after 21-22, so I don't want to say too much more about it, but you will have seen, I'm sure, that we published some own motion investigations last year. You may have seen in BearNet, we've started offering a one-day training for public servants on administrative fairness. We've done some more in-person outreach events. Those have been advertised. So that whole prevention side is really ramping up. There's definitely a lot of interest coming from the public service. We also, just a couple of weeks ago, started piloting a presentation to high school students, just to start building some skills about what do you do when you have problems with government or banks or cell phone companies, for that matter. How do you advocate for yourself? Where can you go and get help? Where can you find more information? So, you know, this is all feeding into that prevention. Having said all of that, I'll go back to what I said earlier about 21-22 having 2 staff working full out to do the complaint handling work. I currently have 2 staff now, and I am really concerned about the capacity of the office to fulfill our mandate. The public education, the own motion investigations, those aren't add-ons. They come directly from the legislation, and I think they're really important. I also would not have any capacity right now to take on any referrals, whether it comes from municipal or Indigenous governments or the Assembly or committee. So as of May this year, I only have 2 staff, and that was manageable during COVID because we weren't doing outreach or in-person events. We weren't doing education, training. People weren't taking long holidays. We didn't have public access to the office for the most part, but that's changed quite a lot. And of course, part of my responsibility as Ombud is to balance balance our resources and the different parts of the mandate. I don't think our complaints resolution process can be any more efficient than it is. I plan, and I have since the beginning planned, that we'll be within a window of about 150 to 200 new case files a year. That'll go up and down a little bit, but it does stay within that range, and the workload, remains consistent. So I can see it's reasonable that I might have to decide, well, I can do 5. I can't do 5 own motion investigations, but I can do 2. But when I'm having the internal conversations like I'm having now, which is, can I even manage 1 this year? And I do think we need to be doing these every year. That's concerning. And, when there's a huge demand for this training, I've been asked to put on more programs. It means sending 2 staff out somewhere, and that means, the office, there's either one person working alone there or we shut it down. So it is to a level where it's concerning. And that's, of course, not the whole workload. We have other things that need to be done. We have some administration. I don't have an administrative position because there isn't enough work for someone to do that full time. So that's things that are being done off the corners of people's desks. Our website needs upgrading. So, I'm concerned about, the long-term sustainability of the office with that. And I do realize that's a conversation I'll need to have with the board and likely the board of the next assembly, but there is quite a lead time to build up that capacity, and that, by the time it gets approved, if the funding's approved, it's April 1st, then there's the staffing process that takes 6 months. And it's really a good I can't pull someone off the street and immediately put them on phones. It's a good 6 months to get somebody trained up before I'm comfortable with that, because you don't know who's on the other end of the phone. There are some calls that are really, fairly straightforward and easy to deal with, but, we deal with people who are pretty upset and pretty distraught, and not everybody's got the skill set to handle that. It can be really angry people. It can be, someone who's just lost a loved one, who's grieving and really upset about something that's happened. Somebody who's really angry, we deal with some people from the correctional system, right, as well, that, come from different backgrounds and different experiences. So, to prepare somebody to be able to do that, what I'm saying is I can't just, substitute in somebody on a transfer assignment like that. There is quite a long process to onboard somebody. So this is why I'm raising this now. Like, obviously this is a conversation to have with the board, but having understanding and support from the committee really does help, because I know the board doesn't have as much time to spend going on statutory officers' mandates, particularly this term. They were really busy, I know, with a lot of matters. So it does help if the more awareness there is about the work we're doing, the better, I think. 5 years does go by really fast. As I said, I'm in the final months of my term. Whatever happens next April, the most important thing for the continuity of the office is the staff. I do think we have a really strong and resilient team. It's a small one now. It's not big enough to deliver the mandate, I don't think. But they've been through a pandemic, a flood, an explosion, a fire. They're pretty resilient and pretty committed to their work. And I get asked how I can do what I do with 2 staff, and it comes down to their commitment. I don't think anybody in my office is there just for the paycheck. Like, in fact, I know that they're really dedicated to what they do. Just on a final note, the report concludes with reiterating the recommendations on legislation that I made in my 1920 report, and as you well know, Bill 61 passed and will actually come into force on Saturday. So that did, of course, deal with a number of the recommendations in the report. I will be doing a follow-up report with the remaining recommendations to just repackage those and perhaps provide some more explanation and detail. Hopefully that will be ready for tabling in August. Again, I expect that will be the next assembly that considers that. So I know it's a beautiful evening out there, and I know it's been a long evening. A long couple of days for you. I can leave it there, but I'm certainly happy to answer any questions. I would just like to mention one thing, which is we haven't ever done an outreach event in Yellowknife up till now, and a couple of my staff will be at Folk on the Rocks. They're going to have a table in a couple of weeks, so if you're there and walking by, please stop by and say hello. They're friendly folks, and for anybody who's listening, they'd love to talk to you. They'll be showing off our new posters and pamphlets and things. So thank you very much, Mr. Chair.
Thank you very much. Are there any questions or comments from committee members? Leigh O'Reilly.
Yeah, thanks, Mr. Chair, and I think we'll see your staff hopefully at Folk on the Rock. So, well, I had a few questions, but I think you actually covered them all. I was going to ask about Section 16 implementation. And I think you said you don't really have the capacity to handle that, so there probably haven't been any referrals. I was going to ask about Bill 61 implementation. I know now that it comes into effect on Saturday, so and then I was going to ask about your own motion and investigation, and you talked a little bit about that. So I guess my one comment is that I think you have a great annual report. It's plain language. It's got great graphics, statistics in it, and it presents your mandate, what you do, what you've done. Really helpful report, really good. In fact, I commended it to the last statutory officer that was here and said, have a look at that report and the way that the stats are presented. So I don't really have anything to say other than I think you've done a great job, and thanks for everything you've done with the outreach and given COVID and stuff. I think you're doing a great job, so I really appreciate the annual report as well. Thank you.
Thank you for those kind words, Emily O'Reilly. Any questions or comments from other members? Elaine Jericho? Mike? Just hit you the button on the mic.
Yeah, thank you, Mr. Chairman, and I just want to say thank you for your presentation, and I'm just, it's a well-done report, and I see your recommendations as well, so I just want to say thank you, and I will continue to go through this and look at it. Let's see.
Yeah, okay, any further questions, comments? Hearing none, I will just reiterate those thanks. This is the end of our 4-year term, and who knows what's going to happen next. That we appreciate, and you know it will be the next committee reviewing the 2022, 2023, or 2021-2022 annual report, and we look forward to that time. But thank you for all of your work. I know that is very similar to an MLA at time in trying to get these calls and navigate the complaints and the issues of government, and we refer many people to your office and greatly appreciate it. So thank you for appearing before us today.
Thank you.
Mr. Chair, sorry.
Oh, Emily Semler, did you have a question?
I did have a question.
Perfect.
Sorry, I
Go
was
ahead.
trying to get off mute.
Go ahead, Emily Semler.
And thank you for the presentation. And I know my colleague had mentioned it, but I'm just wondering if the Office of the Ombud. I know that a lot of times we bring up issues from constituency, Indigenous. And I know, and I'm not sure if you, sorry if I missed, I've been having troubles with my Zoom connection. With type of feeling, I guess, racism against them. And I know you spoke to a little bit about people not answering their calls or waiting. I think in your report there was one point there was 3 departments and it took them 8 months to get back. And I'm just wondering if there's been any complaints like to your office on, you know, being mistreatment of being like racist treatment against Indigenous people, because I know that's been brought up and it, you know, sometimes as an MLA you bring it forward to the department if there's a concern, but is there, you know, we feel like sometimes it's like human rights and people say, well, I've done that and it doesn't work. And like, I know you mentioned that and I know the Ombud is new. And I'm just wondering if there's more complaints coming to you in that nature, or have you had any, or would your office be the place to be able to bring something like that forward?
Thank you, Emily Semler. Ms. Langlois?
Yeah, thank you, Mr. Chair. So if, you know, this gets into a bit of the tricky interpretation of the statute, Section 23, which I know was discussed during Bill 61, which prevents me from investigating a matter that could be a matter within the jurisdiction of the Executive Director of Human Rights. So absolutely, if somebody came and said to us, I feel I've been discriminated against based on my race, I would absolutely want them to go and talk to Human Rights. That's where something like that belongs, for sure. Where it gets trickier is sometimes people come with a whole story, and one of their ideas might be that it's based on racism, but then they think it might be something else too. So yeah, I feel that there was racism involved, and I also feel that, you know, this whole process was unfair because they never listened to me, and they don't listen to anyone. And so it gets, and this is kind of my concern with that section of the bill is too, it gets really tricky for my office to be able to determine, well, you know, is this something that we should be looking at or isn't it? So absolutely, people do contact us and sometimes raise issues, you know, where they feel there's discrimination. And what we'll often do is ask, okay, do you think are you concerned about dealing with the discrimination? Or is it the other piece that's more concerning to you? Because we really can't do both. So if they want to talk to Human Rights about discrimination, that's what we would recommend to them. But sometimes they'll tell us, actually, I just want you to look at the process because I think they're doing something that's no good there. Or maybe they want to do both and they're pursuing both sides with us. I mean, definitely, it's difficult sometimes to carve out that piece. We definitely don't ignore those issues, and if there's something we can do, we do. And absolutely, you know, I will hear somebody out, or my staff will hear somebody out who thinks they've been discriminated against for any reason, and then we'll go from there. I know I have heard those issues too from some complainants where they've been to Human Rights and for whatever reason they weren't happy with the process. I know Human Rights has done a lot of work in the last couple of years, particularly since their new amendments came in on restorative justice, on making the adjudication panel, you know, easier for complainants to navigate. So it may be that things have changed. We also do a lot, like we'll sometimes have 3 or 4 conversations if we really think that you know, something belongs with Human Rights. You know, we'll often have a few conversations with people to get them comfortable going back there. You know, we'll say, well, you know, maybe it didn't work out that time, but this is a different issue, and it might, you know, the outcome could be something really different, and can you just try and go talk to them? And if they tell you they can't deal with it, come back and we'll see what we can do. So yeah, it is complex, but certainly, you know, we're aware of it. It's at the back of my mind, you know, especially given the demographics here with every complaint that can be an issue. And it's often intersection, right? You know, social condition is another issue. It can be gender as well, right? There's a lot of things that intersect there. Thank you, Mr. Chair.
Thank you. Any follow-up, Emily Summer?
Yeah, I guess kind of, I know that's the Ombud, from my understanding, and I think for myself, I deal with a lot of constituents' concerns, and not just my own constituents, but I get contacts from throughout the Northwest Territory when they're feeling that they've been unjustly in a HR competition. And I know that this government has done lots of work on different areas like Indigenous recruitment and retention framework, because I think Indigenous people as a whole in the Northwest Territories feel like they've always been, their experience has never been graded or equivalent to somebody coming from the South. And so when they apply on jobs, for some, you know, for many, you know, they'll get the job, they'll be screened out and no explanation. And even when they're saying there's equivalencies, but nobody ever gets to question, well, what did my equivalencies not meet? You know, like I think there's a lot to play within that area, that the government is not doing the same everywhere. And I think that's, you know, with something that with the Ombud, I'm not sure if that's something that you've encountered, or have people not brought that issue forward to you, because I know that with processes, we have policies, we have processes, we have frameworks, and we're still finding that people, oh yeah, maybe they shouldn't have been screened out. Oh yeah, maybe that person should have been not interviewed until, you know, because of the affirmative action. That's not how affirmative action is done, you know, and we hear it only after the fact. Oh, we shouldn't have done that. We shouldn't have, but we're so used to hearing that. And I think Indigenous people just get tired of applying because they're so used to being turned down. And I'm just wondering if there's something in your office and, you know, that maybe that's something that maybe you can look into if that's under your area. Thank you.
Thank you. Ms. Langlois?
Yeah, thank you, Mr. Chair. So that issue of, for example, not being screened in and not really getting any explanation for that, that is absolutely the kind of thing that we can look into. So while I can't, you know, look into whether they were, that was because of discrimination, I can definitely look into whether, you know, there were enough reasons provided for the reason the person was screened out. If anything happened in the process that shouldn't have happened, if they weren't following their own process, if that wasn't done properly. So yeah, those are definitely things that I can look into. You know, this is where also, you know, whether it's HR or another area, this is where those own motion investigations can be so important too, because if I'm dealing with one individual at a time, I am only looking at that one competition and only, you know, probably a couple of letters and a couple of people. I'm not looking at the whole system, and sometimes it's not what happened in that specific competition. It's actually a much bigger issue that's going on, and it's hard to uncover those with individual complaints. So, yeah, in short, yes, those are absolutely issues we can look at. Anything to do with the process or the explanations given or the communications with people. Thank you.
Thank you. Any further questions, comments from the committee?
Yeah, I just have one more follow-up on that, and I know that, if I may, Mr. Chair?
Of course, go ahead.
I know that within the new with the legislation now that members, you know, different people can, Indigenous governments, because I know we've received letters, even myself, from Indigenous governments stating that, you know, the affirmative action policy is not doing its job, the government's not following it. And so, you know, I know that you said that you don't have the staff right now to take on something that big, but is that something that, you know, that, like, I don't know, in the next government that, you know, like how we kind of recommend to the Auditor General, we kind of say where that we see a lot of issues as members, and then they decide what they're going to audit, the Auditor General. But I mean, as a big picture thing, I know affirmative action hasn't moved. We haven't raised the level on it, and we've heard so many complaints. And as an Indigenous person, you know, working in the Northwest Territories my entire career as a government employee, you know, I've heard from other people throughout my life here with the frustration and with the process. And I'm just wondering if that's something that we can put on your radar, or something to, when you have time, or if you do end up with needing getting more staff in the future, that you can look into further. Thank you.
Thank you, Emily Summer.
Yeah, thank you, Mr. Chair. Yeah, I'm always open to suggestions. I can let members know that about 5% of our case files have something to do with hiring. So that is, you know, that's pretty significant, right? When you look at all the things that we're dealing with. So it's absolutely an issue that I'm aware of. Specifically with affirmative action, and this is just so members know, like when there's a big policy review going on, and I know that they're looking at changing the affirmative action policy, it's probably not something I would do a deep dive into. I would probably want to wait and see what the new policy is, because I don't want to end up doing a bunch of work and making recommendations that, you know, they're going a different direction anyway, or they've found a different solution, or they were going to do the same thing anyway. You know, but certainly, you know, the referrals can always get made, and then, you know, we see whether we can take them on or not. Thank you, Mr. Chair.
Further questions, comments from the committee? Hearing none, we will end this public meeting. Thank you very much. Committee will take a couple-minute break.